Yeah, when I was listening to Joe and Jim, an early case I had came back to mind, about 20 years ago or so. It was three people that were in a Mercedes coming back from a trip, and they were down on 99, down in the valley, and they got involved in some of the Thule fog. And our client's semi-truck, rear-ended them in the middle of all the fog. And just the vision that never left me was the driver telling me I had a load of cattle, and he goes, "I stopped, the cattle didn't." So that's just never left my mind on that, from thinking what he's talking about with the dynamics of the stopping speeds. It's like I said, still comes to mind here. I'm going to be talking, as Ashley said, about insurance coverage. The first case we're going to talk about is the biggest case that's come down in a while, which is State of California versus Continental Insurance. This is a what they consider a continuous loss or long tail claim. It was a pollution claim. It went on over years and years, decades. And the question that arose here that went up to the Supreme Court was whether the limits of the insurance policies, all the various policies, could be stacked. Prior to this, the FMC versus Plysted case had said that an insured had a right to recover a defense from any of the policies on a continuing loss, pollution, or construction defect deterioration claim. But they only got one limits, and it would be shared some way between the carriers, or they could get it from one carrier who was free to then go after the others for some sort of apportionment. But what the court said in the State of California versus Continental Insurance, actually what they did was they affirmed what the Court of Appeals had said, which is that, look, the insured buys this $1 million policy every year. They pay a premium for $1 million every year. If they paid all those premiums, they should get the $1 million for each of those years. So under this case, what had happened was the court said, yes, each of these policies is going to be liable up to their limits. And this decision, the Court of Appeal came down with it in 2009, and we were waiting for a long time. And finally, this last August, the court came out with a decision. Or actually, it may have been May, I'm sorry, but it's been a while. Last year, sorry. Zhang versus Superior Court is another important Supreme Court case that was decided. This was a case where Mr. Zhang had a property damage claim, and he wasn't happy with the manner in which the property was being repaired. I think there were some of the line of sight issues. He felt that they didn't do complete repairs to everything they were supposed to do, and he sued the insurance company for bad faith. He filed various causes of action. Bad faith, he sued them for false advertising and misrepresentation with a claim saying, hey, your ads say that you're going to take care of my claim efficiently, fairly, and quickly, and you didn't do that. Oh, and by the way, the California Fair Claims regulations require you to do all those things, and you didn't do those things. So I'm going to throw in a claim for the violation of unfair competition laws for all these factors that are actually part of the Fair Claims regs. And the insurance company said, wait a minute, there is no private right of action if you violate the California Fair Claims regulations. The Department of Insurance regulates whether insurance carriers follow the regs, whether they're handling cases in an appropriate manner, but the insured does not have that private right of action. Well, what the Supreme Court said in this case is, just because these factors A through D might be what you would see in a claim for violation of the Fair Claims regs, these are four things lifted directly out of insurance codes or the claims regulations. I think it's 2695.5. They lifted some of these items right out of there and made that part of the unfair claims loss claim. And the court said they may be violations of the regs, but they also are unfair practices. They're false and misleading representations, and they really should be the basis for a separate unfair competition law claim. I think a big part of the case too, throughout, if you read the case itself, throughout it, what the court kept saying was, unfair competition law, the only things you can get are disgorgement or equitable relief. You can't really get damages, attorney's fees. So they were trying to say, well, it's not that big a deal to add this anyways. It sounds like it should be an unfair competition law claim, and we're going to let it in because the damages really aren't that great. But of course, the problem with this is, what this means is the plaintiffs are going to be starting to use the claims regs and say, here's the regulations. They're supposed to do these things. They know they're supposed to do these things. And when they don't, they're now violating unfair competition laws. So that's the downside of the Zhang case, and we'll have to see how far it goes. These next couple cases, Hughes and Henderson, These were two cases that were pending before the Supreme Court. They were both basically tracking on the same idea as to whether you could bootstrap a violation of the Fair Claims regs into a cause of action under unfair competition laws or otherwise. They were both basically pending the decision in Zhang. It is the Zhang case that came down this August. It was last August for state of California. Once Zhang came down in September, the Supreme Court sent both Hughes and Henderson back down. What that means is the Court of Appeal decisions that they stand for, which essentially said you can have that kind of a cause of action, those particular cases are unpublishable. But it doesn't matter because the Zhang case really says you can do it anyways. So these cases aren't citable anymore, but I wanted to leave them in just so you knew that that's where they had been, and we've been reporting on them previously. The only other one we have pending of note from the Supreme Court is Hartford Casualty versus Swift Distribution. This is kind of an interesting case. Mr. Dahl manufactured a product called the Multicart. This other company manufactured a product they called the Ulticart. And Dahl sued them, claiming, disparagement, that they were damaging his copyrights and they were harming his product. The people that made the Ulticart turned it over to their carrier. The carrier, Hartford, said, we don't owe you anything here. A policy under personal advertising or personal injury, coverage B of a policy, typically will cover any advertising or anything in a business that will tend to disparage or libel the particular product. And what the court said here is, Ulticart never mentions Multicart by name. They don't ever disparage them, so there's not going to be any coverage for that claim. So the Court of Appeals said there was no coverage for it. That's been taken up to the Supreme Court, and we're waiting on that one to come down. Due versus Allstate, I'll just mention very quickly, it was a federal case. When this came down initially, what had happened was there'd never been a settlement demand. The plaintiff was injured. The plaintiff had kind of a flaky attorney. In fact, I think went through a couple of different attorneys. And the carrier never got a chance to make a settlement offer. Ultimately, then, they did get the damages. They did deal with the case, and it went to trial, and a verdict well in excess of the policy limits was obtained. So Due sued his carrier, saying, "Hey, you should have made a settlement. You should have made a settlement offer in this case, and you haven't acted appropriately." And initially, the federal court had said, if you look at the Fair Claims regulations, the Fair Claims regulations say you will settle a case, you'll do it reasonably. Where evidence is clear of liability, you will attempt to get your insured's case taken care of. And the federal courts initially said in Due, if you don't make a settlement offer that long down the road, you are in bad faith, or you're potentially in bad faith. So we're going to let this lawsuit go forward. It went up on remand, and when they reconsidered it, they basically took the easy way out on the case and said, the other basis for the appeal in this matter was that Due wasn't allowed a jury instruction that went over some of these bad faith issues. And we're going to really decide that there was not enough evidence to support that jury instruction. We'll decide on that alone and leave it for whether California really thinks there's a basis for a bad faith claim if you don't make an offer. So Due is still out there, but it is of lesser effect. We do have a case a little further on I will get into, which recently reaffirmed. The Reed case, which just came down this year, again dealt with the issue and came back squarely in the camp that if you don't have any settlement demand, the carrier has no obligation to make an offer on its own, with a couple of caveats we'll talk about when we get to Reed. Here's a miscellaneous case. Pacific Rim Mechanical Construction. Actually, this case I really like to point out because it happens quite often in the construction industry. This was a case involving construction of a project. The owner, or the developer, purchased a RAP policy for the project. Everybody familiar with RAP policy in construction? It covers the whole project, and all the subs pay into it, and they all share in liability. So that way, instead of going through a number of different policies, it's all covered under one Uber policy, or that's the idea behind a RAP policy. So it was purchased through Legion, unfortunately, and the project was completed in 2002, just as Legion was having some problems. After the project was totally completed, Legion went into receivership and dissolution. The policy had been provided to the contractor and developer originally through Aon Risk. They were the ones that sold it. And when Legion went into receivership initially, Aon contacted the developer and said, hey, there's a problem with Legion. They're in receivership. You might want to take a look at this. So they let Legion know, but they let the developer know, but neither the developer nor Aon contacted any of the subs, including Pacific Rim, who was kind of one of the last subcontractors onto the project. So Pacific Rim didn't know that wrap policy was no longer any good. And sure enough, a couple years later, when a lawsuit arises over construction defects, the case goes forward and the Legion policies aren't there. There are some other policies that might cover things for some of these other parties, but Pacific Rim found itself without insurance. So they sued both the developer and they sued the broker. Aon Risk Services said, you guys should have told us that this policy was no longer in effect. And because of that, now we have no coverage for this. And the significant import of this case is that the court looked at this and they have a good discussion of what broker duties are and are not. And what they ultimately determined in this case is that brokers are not liable to persons such as the subcontractor in this case because they weren't dealing with them directly. The subcontractor did obtain it and they obtained the certificates from them, but really the policy was sold initially to the developer. So that was the only person that they could conceivably have any duty to advise. Axis Surplus versus Glencoe. This is a self-insured risk issue and a couple of issues with a couple of carriers. In this matter, there was significant construction defects. Axis and Glencoe were successive liability carriers for the insured, and the policy with Glencoe had a $250,000 self-insured retention. So, case gets tendered to both Axis and Glencoe. Axis picks up the defense. Glencoe doesn't. They said, you got to satisfy the SIR before we'll come in. Case went forward on a lot of issues. They had a lot of discovery. They determined a lot of the damages. It was very clear there was at least a $1 million plus damages that would pertain to the insured's work, or at least that was even the defense position in the underlying matter. They settled the case for $1 million, which consisted of $750,000 from Axis and the $250,000 SIR from the insured. Now, before they settled the case, the insured and Axis went to Glencoe and said, look, we're settling this case now. Do you have any objection to the insured contributing the SIR at this point? And Glencoe said, no, we don't. So go ahead. Feel free. I'm glad you're getting rid of the case. We're all happy. We'll all go away happy. So they settled. They entered into the agreement. The insured's money is paid. The case is dismissed. And then Axis proceeds after Glencoe and says, I want to recover costs of defense in this matter. And Glencoe argued that its policy didn't apply because the SIR was not satisfied. And the court said, no. When we get to talking about subrogations between insurance carriers, we're talking equities. And in this particular case, you were advised all along what was going on with the case. You knew the insured was being asked to contribute. You knew Axis was paying into the thing. And the second that Axis was basically ready to pay off on its full claim, you understood that you would have been involved at that point. So the court said, we're going to allow Axis to get monies back from you on this matter. Unless anybody is heavily interested in bond cases, I'll skip over this particular one. It was a big project where both the developer and the general contractor went belly up. The paving subcontractor had never been paid. They attempted to collect on a bond, and there are all kinds of deadlines with bonds if they're public bonds. And this was a public bond taken out by the developer because he was doing improvements for the city of Los Angeles. But the paver argued, hey, I've got a contract with the general, and I'm just doing private work for him. I've got a private contract, so all those statutes and the time limits don't apply. And the court said they do. We have to look at the overall project, and the overall project here was a public liability project. Global Hawk versus Century National. This was a trucking case, and a truck rear-ended another vehicle. The truck was not on one of the scheduled vehicles for the trucking company, unfortunately. They did have an MCS 90 form, which in trucking forms, I understand, provides that you will be responsible for any vehicle that is used on your projects as long as there's no other insurance. And it's a fail-safe, and it's a minimum requirement that you're required to do if you're doing interstate trucking, which these folks were. Well, Global Hawk said, we have no coverage for this because it's not one of our scheduled vehicles. They didn't pick it up. So the employer suggested, and the plaintiff ended up going to the underinsured motorist carrier, or the auto carrier for they went through the carrier for the uninsured motorist carrier for the plaintiff driver, and that would have been Century National. Century National paid its limits on the case, and then it went after Global Hawk saying, you guys should have picked this case up because of the MCS 90. Global Hawk argued that the language on the MCS 90s say that they will pay if there is no other insurance available to the insured. And Global Hawk's argument was there was other insurance through the plaintiff's auto carrier. And the court said, no, that's not the trucking company's insurance, that's someone else's. So Global Hawk or Century National had to pay up there. Ortega versus Toppa. If any of you write auto policies or involved in auto policies, particularly some sub-policies where there are changes or restrictions from what the law normally would otherwise allow unless you limit it, this is an important case. In this one, the carrier provided that they would use non-OEM parts, which an awful lot of people do, but they also provided that if you went to our preferred provider shop, we'll pay 100% of the repairs. If you go somewhere else, we'll pay 80%. And when you applied for this particular policy, the application said in big bold letters, this is a restricted policy, please read. And on the front, on the page where the person had to sign the application, there's a boxed off area, and it said certification of approval of limitations. And it basically says, I understand that I'm not getting everything I would under a normal policy. I'm good with it. They signed off on it, they got the policy, they got in an accident, the vehicle was repaired with non-OEM parts, and the owner wasn't happy. So the owner, Ortega, sued Toppa on behalf of himself and everyone else in a class action, saying that this was a violation of the Insurance Code Section 758.5D as to what you can do and what notice you have to give. And the court said what you have to give, the language has to be clear and conspicuous. And there's no real definition of it, but the court said here, when it's in a box, when it has big bold lettering saying this is a restricted policy, that was sufficient. I'm going to skip over Pierce versus Western Surety. Carson versus Mercury Insurance. This was a kind of an interesting case. Just almost from the fact pattern alone, I just feel sorry for this lady. Mary Carson, at age 65, bought her first brand new car ever, a 2008 Honda. She bought it in 2007. She gets in an accident shortly thereafter. Her brand new car, first brand new car ever. She goes to get it repaired. She goes to Mercury and says, I've been in the accident. The policy had a option for Mercury to either repair or to replace the vehicle. And Mercury chose to repair the vehicle. They took it, it was valued at one of their preferred provider shops that said, yes, this vehicle can be repaired to its pre-accident condition. She chose to go to a shop of her own. She took it to the shop of her own. They did the repairs that were initially noted. When they got it opened up, they found out there were additional matters that needed to be fixed. So they then went ahead and did that. And they ended up spending about $25,000, I think, on the vehicle. And it was a $31,000 car, brand new, a few months earlier. But it's a Honda, and they don't lose their value, as we know. So she argued, you should have replaced my car. And it was not restored to its pre-accident condition. So therefore, you're in violation here. And she sued over that. But the court here focused on the fact that even her witnesses that looked at this vehicle said it could have been restored to pre-accident condition. It just wasn't in the manner that it was done. They didn't do it right. And the court said, since it was her choice of where to have this done, and since even her people said it could have been restored to pre-accident condition, it was sufficient to allow them to repair the car. Guide 1 Mutual. This is an interesting case just almost from the standpoint of the math. The short and simple on this, there was a minister with Crosswinds Church, which was part of the larger Christian Evangelical Association, CEA. So you have Minister West, Crosswinds, and CEA. Minister West is taking out some friends, or actually I guess it's a visiting person, but it is a business lunch. They go to lunch, they get in an accident, and it's significant injuries to the person in the other car, and he's sued. He has a $100,000 policy with State Farm. The case ends up settling for $4.5 million. First goes the State Farm $100,000. Crosswinds had a policy with, which were they with? They were with Guide 1. Yeah, they were with Guide 1. Crosswinds policy of $1 million liability was with Guide 1. Crosswinds had an excess policy with Guide 1 for $1 million. Utica insured CEA, the larger national organization. They had $1 million liability and $5 million of excess coverage. So we got $4.5 million here. So we took $100,000 from the minister's policy right off the bat. Both of the $1 million liability policies went. So that's $2.1 million. The remaining $2.4 million came out. The entire $1 million from the Crosswinds Guide 1 policy and $1.4 million from Utica National's $5 million policy. Guide 1 then turned around and said, I'm suing for contribution. I think I paid too much here because I have $1 million of excess monies, you have 5. I got 1/6 then of the total excess monies available, so therefore out of 2.4 million excess, I should have only paid 400, so give me 600,000 back. Trial court said, okay, sounds good to us. The math works, okay, we'll do it. So Guide 1 got their money back at trial court level, but the Court of Appeal looked at this and said, again, when we look at contribution and subrogation actions, the first word in front of that is equitable. So we're looking at this and we're saying, we're going to do this in a manner that seems to us to be equitable. And here, the only reason anybody was coming after CEA was because it was a master organization for Crosswinds, which was the employer of the guy who was negligent at fault. And they said if you look at a normal case not involving excess insurance, the employer is going to be at fault vicariously for the person for their employee. And if there was ever an issue of apportionment between somebody who's actively liable versus somebody who's only vicariously liable, you're going to lean towards the person who is actively liable. And in this case, they said Crosswinds and its minister were the ones that were actively liable, so therefore, we're going to exhaust the Crosswinds policy. Their $1 million excess goes before the money would have been paid by Utica for CEA on their amounts. So basically, they left the status quo, and so it worked out. It worked out the way that they had originally agreed at the settlement. But it was done on equitable principles. Progressive Choice Insurance Company versus CSA. This is what I call no good deed goes unpunished. Most auto policies on an uninsured motorist claim and the state of California on uninsured motorist claims have provisions for how you deal with insurance. If I have my policy of insurance and I'm in Ramsey's car and we get in an accident with an uninsured motorist, whose policy do we go after? Do we go after, does my policy kick in, or do we go after someone else's? Well, the other insurance provision under the state statutes are the policy of the person who's in a vehicle that's not their own, or they're a passenger in a vehicle not their own. That policy is not providing any coverage. AAA went a little further beyond that. What they said is, if you are liable as a passenger in a vehicle you do not own, our policy is excess to whoever's policy belongs to whoever's driving the vehicle. So they're actually giving a little bit more in coverage. But the problem with that was, by giving something that was different from what the statute was, they couldn't then rely on the fact that the statute said we don't apply at all. So the court, AAA was trying to use the statute here against Progressive after the case was settled, because Progressive was coming back trying to get contribution. And AAA said, well, look, we're excess to you. And the court said, you can't rely on you being excess to that because you haven't met the statutory limitations. You've actually altered that. So by giving actually more, they ended up in a situation where they had to end up contributing. Whereas if they just had actually incorporated the actual language of the insurance code section on uninsured motorists, 11582, they would have been in the situation where their insurance wouldn't have been involved. Travelers Property versus Charlotte Rose. I mentioned earlier that there's the case that's up on appeal, Hartford Casualty versus Swift, over trade liability or disparagement claims. In this one, the manufacturer of the clothing line entered into a deal with a department store chain to sell their goods. And the manufacturer of the clothing line wanted to promote their clothing as really high end. You know, this is something you're going to spend a lot of money on. This is something only exclusive people are going to have. Well, the department store started getting them, and they started having some issues selling some of them. So the department store started putting on signs, 80% off, 90% off, putting them in bins, doing things like that. The manufacturer of the product sued Charlotte Russe saying, hey, the manner in which you guys are selling these things now is libeling it's disparaging our product. This is a high-end project, and you're selling it like it's bargain basement fire sale goods. This is causing detriment to our product line and making it worth less simply because you're telling everyone it's worth less. So they sued Charlotte Roos. Charlotte Roos turned around and tendered to Travelers. Travelers said, you're claiming coverage under the personal and advertising injury, and that does cover disparagement, someone who does something that disparages or libels your product. Well, Travelers focused on the requirements for libel, and there was no indication here that anything that Charlotte Roos had done actually called that product a bad product. The Court of Appeal actually tried to say, you could arguably make a case that they were libeling it, but they didn't even go there. What they said is, you have to read the entire provision in the personal advertising injury. It is usually disparagement, slander, disparagement, and or libel. So they said you can't say because it doesn't fit libel, it doesn't fit this, because there's also disparagement, and disparagement means putting it into a bad light or making it just not worth as much. And they said clearly what was going on here with the bargain basement tactics were making it worth less. So there was at least the potential for coverage. So Travelers had to defend, or actually had to answer up for that case. Enton versus Superior Court. This was a disability claim. Dr. Enton suffered injuries and began having migraines to the extent that he could no longer work. He had a long-term disability claim. He filed for the claim. The disability carrier proceeded to pay on the claim. They did not feel he was permanently disabled, though, so while they were paying on the claim and while things were going forward with it, they did everything they needed to do and kept making payments, but they had him seen by their own physician. Their own physician said, I don't think he's totally disabled within the meaning of the policy, from what I can see. And they also had concerns about some of the treatment that he'd been receiving. So they filed a DEC relief action, and they said, okay, we're continuing to pay until the court rules on this DEC relief action because we want to do everything right. So we're going to file this DEC relief action to say that under the terms of this policy, he's not totally disabled. And you know what? That's a contractual matter. We're only seeking an equitable relief from the judge. There's no right to a jury trial when you're seeking equitable relief. And Dr. Enton said, I want a jury. And so that was what the dispute was over this. And what the court said was, the issue here, no one was disputing what the terms of the policy said. The issue here was really whether this man was totally disabled. And it's not, the words totally disabled weren't defined in the policy, so it was going to come down to a factual determination of whether he was disabled. Consequently, he was entitled to a jury trial in that matter. St. Paul Mercury Insurance versus Mountain West. Simply put on this one, you've got general contractor, subcontractor. Subcontractor's carrier, Mountain West, was supposed to have the general named as an additional insured, and they did. Case lawsuits filed, tendered to both St. Paul Mercury for the general and to Mountain West as the additional insured carrier. Mountain West did defend the subcontractor, and Mountain West contributed on behalf of their roofing subcontractor substantially to the settlement of the case. St. Paul, though, sued for equitable contribution, claiming that they had paid too much of the case and that Mountain West hadn't paid anything on behalf of the general. Mountain West defended that by saying, we defended the case, we took care of our subcontractor. You wouldn't think it would take a lot to make the distinction, but the Court of Appeals pointed out to Mountain West, no, you participated for your named insured. You didn't participate for your additional insured. So therefore, you can't dispute that there was a determination as to the damages, and you can't dispute the liability, and therefore, we're going to find that contribution's appropriate. I'm going to skip over this one because it involves lawyers and malpractice, and it's just scary. So, too late in the day to be talking about that. Mount Holly Insurance Company versus Lopez. This is a case where Dr. Lopez allegedly was responsible for channeling a liver for a transplant to a patient other than the person it was designated to, and then falsifying records and forging tests to cover up. Again, it's not the crime, it's the cover-up afterwards. But actually, it was both those things, allegedly, that got him in hot water with the federal government. They filed a criminal action against him for these activities. He tendered the defense to Mount Holly Insurance Company, which was the insurance company for the hospital that he worked at and for him. Mount Holly said, look, under Insurance Code Section 533.5b, we can't defend you. insurers are not responsible for intentional or criminal acts under Insurance Code 533. And Insurance Code Section 533.5b was added to basically say you don't have a duty to defense either, because the idea was these people were getting sued over these types of things. The insurers step in. If no one's paying for the defense of matters like this where you've got a criminal action, there's less incentive for somebody not to obey the law. So 533.5 says you don't have a duty to defend either. And that was what Mount Holly had hung its hat on. But what the court said here is that if you look at the language of the statute, it says from any action involving state or local prosecution. It doesn't say federal prosecution. And the court said the statute expressly directs it to these two and not to federal. We're not going to say you can't defend, because normally when someone's accused of a crime, they're entitled to the defense that they're innocent, unless there's a statutory reason otherwise, and this statute didn't address federal. Mount Vernon Fire Insurance versus Oxnard Hospitality. Ms. Busby was a dancer at a gentleman's club, and unfortunately, it's actually tragic what happened to her. There was some wacko customer who threw a glass of flammable liquid onto her, and she was very badly burned. She sued her employer for negligent security. I guess these dancers are treated as independent contractors, so I'm assuming that's how she got around the workers' comp laws. The employer, Oxnard Hospitality, tendered to its carrier, Mount Vernon Fire Insurance, and they denied on the assault and battery exclusion. They said, look, our policy doesn't cover any claims for injuries arising out of an assault and battery. And then there were definitions of what an assault and a battery were. So since there was no coverage for the claim, Ms. Busby ended up getting a judgment of $10 million against Oxnard by stipulation and an assignment of their rights to proceed against the carrier, and then she sued the carrier for bad faith. And she argued that the exclusion didn't apply because nobody touched her. It was the liquid that struck her. And the court actually, I think it makes a lot of sense, but they really take it step by step. They said, okay, if the patron walked up to her and hit her with a glass bottle, nobody'd be denying that there was physical contact there. So if that bottle or glass was full of liquid and the bottle doesn't touch her, but it's the liquid that hits her, how is that any less contact? It's the same physical action. It has consequences and injuries. So the court said the assault and battery exclusion did not require that there be physical contact directly between the two. Physical contact of the action and some injuring device was enough. Swanson versus State Farm Insurance Company. This is a new case, just came down about a month ago. In this particular case, the carrier was tendered to by the insured's personal counsel who was defending an action. The carrier took a look at it. They then send a reservation rights letter saying, okay, we're going to defend, and okay, we'll approve you, Mr. Personal Counsel, but we pay $150 an hour. You're getting $200. You're going to have to get the extra $50 from her, and we're going to need to see that you have enough work with this. Basically, all the diligence you need under a Kumis 2860 case. He had to show his errors and omission insurance was in place and that he'd done this stuff. He did that. They satisfied it. They went forward, and they started defending the case. 5 months into it, though, State Farm revised its reservation rights and withdrew a great number of the reservations that they had made. And they said, okay, now that we've withdrawn our reservation rights, there's really no need for Kumis counsel, so we're not going to pay you anymore. And the insured had stated, well, once we had all these discussions about how much you're paying him, you took this beyond the insurance contract. So we had a different contract, and this is something that we need to take before the jury to see how that gets determined. And the court said, no, really, Kumis is a creation of statute. The statute prescribes what is and isn't allowed. And in this particular situation, there's no one disputed that once the reservation of rights was revised, the actual conflict that created Kumis no longer existed. So the insured, the lesson for that is if you have a case where you've got a reservation of rights, if the facts turn out to be that the reservation is no longer needed, you don't need to keep paying Kumis. I don't know if they covered this case in the sessions earlier, but this is a case that just came down also, American Safety versus Admiral Insurance. And in this particular case, Admiral insured the general. American Safety insured the subcontractor. It had an additional insured for the general. Case is tendered. Initially, American Safety denied the tender on the additional insured endorsement. Case actually went they went into litigation over that matter, and they settled the bad faith claim that the general had brought against American Safety by saying, okay, we'll provide you with coverage, we won't withdraw, and we'll go forward from there. And they went forward and they settled. And American Safety then turned around and sued Admiral, the general's own carrier, and said, we want to get our money back because you didn't participate. Admiral said, well, wait a minute, we have a policy, the insured's policy with us has a $250,000 self-insured retention. The problem was the language of that retention very clearly said the $250,000 applies only to damages otherwise payable under this policy. And the court said damages means damages. What that means is that this $250,000 applies to indemnity, but it doesn't apply to the duty to defend. Many policies do provide that the SIR does apply to defense as well. This one didn't. I'm going to skip the DeWitt case because we've got another one that discusses kind of the same issues. Hojet, I'm going to skip that. The only thing that's worth noting about Hojet was it was a car that was purchased, a used BMW, one of these aftermarket type ones. It was allegedly stolen. The insured, when he reported the theft claim, he had 3 different versions of what he paid for it. The title documents said a different number. He had 3 different versions of when and how the car disappeared. He and his wife had 3 or 4 different versions of what the costs for repair were. And the insurance company said, no, we're not paying anything. We think this is fraud and we're not going to pay. He turned around and sued the carrier, and the court said, no, you haven't shown breach of contract because you haven't complied here. You have not provided any facts that support the claim. So for fraud claims, I think that that's an important case to keep in mind. Barnes versus Western Heritage, real quick. A young man was injured in an after-school activity with the district. After he was injured, he submitted medical bills through his family to the district. The district's carrier, Western Heritage, paid medical bills initially, but the district's carrier never sent out a letter to the family saying all medical payments under the MedPay have to be incurred and reported within 1 year of the incident. Nothing about that was said to them. They mentioned it to the district, but they didn't pass it on to the family. So more than a year after the original injury, the family submitted additional bills to the district under the MedPay claim. And by this time, they had a third-party lawsuit pending against everybody else, and Western Heritage was defending the third-party lawsuit. But Western denied any further payments on the MedPay, saying, it's more than a year and you didn't submit anything, so we're not paying anything more. After the denial of the MedPay claim, they then settled the third-party claim on behalf of the district and everyone else involved, and it was a 1542 waiver and release of everything. So after they settled that claim, the minor, through his family, brought a bad faith claim against Western Heritage based on the denial of the medical payments claim. Western Heritage first off said, everything's wrapped up in this, the third-party settlement, and the court said, no, it isn't. These are distinct, separate duties. The settlement of the claim on behalf of the district was your duties to your insured, the district. The MedPay claim is your duties directly to that claimant, and therefore you owe them a separate duty for that. And the fact that you didn't let them know within 1 year means that there's a question of law as to whether you're going to be liable or on the hook for some of these later damages. Reed versus Mercury Insurance. I mentioned this earlier. This is why the Dew case and a couple of the others I think are a little less significant. In the Reed case, it was another one of these fact patterns where the insurer gets the claim, no settlement offer is made, as opposed to Dew, where there were simply no facts until all of a sudden the insurer got medical bills, got a demand and everything else. In the Reed case, there had been discussions going on. The carrier knew what the value of the case was, but there'd never been any settlement demand by the claimant or plaintiff's attorney. The attorney had asked, what are the policy limits? And they were given the information on the policy limits, but they never expressed any other discussion about settlement. The case goes forward. The verdict is in excess of the policy limits. So therefore, there's a bad faith suit brought against Mercury, the insurer. And the claim was that Mercury knew that there was liability against its insured, and they didn't initiate settlement negotiations and get the case resolved for policy limits. And what the court said here is, looking at every case the federal court has, even looking at Dew and looking at everything else we've seen, there's nothing that says a carrier has to initiate settlement discussions where there's been no indication or raising of the settlement issues by the other side. If the other side instigates settlement discussions and the carrier doesn't, then you potentially have a bad faith situation. But where the issue of settlement has never arisen, the carrier can't be found liable for bad faith in that situation. At least not for bad faith failure to settle a claim. I'm going to skip some of the procedural issues here because we are pretty much done. One of the last cases I want to point to is actually the very last one we've got here, since we've got virtually no time left. But this was another recent case, Liberty Mutual Insurance Company versus Brookfield Crystal Cove, LLC. If any of you do anything with construction defect, you're familiar with Civil Code Section 895, et cetera. These were initially the Calderon, and then after Calderon, some of the other issues that have been attempts to deal with construction defect claims, and particularly 895 was enacted to do away with the Oz decision. And the Oz decision in construction defect cases said, if I've got a firewall that doesn't have the right kind of insulation, doesn't have the right bracing or something like that, it's not damaged. It's still doing everything it's supposed to be doing right now. So it's not property damage, and it's not something that plaintiffs can recover for. They don't have a right to those damages. What this particular case here said was, when the Right to Recover Act comes in and says, here's how you handle claims with no actual damage, and you have this is the manner in which you do it. In this particular case, it was a subrogation claim that came in, and the carrier had attempted to get the monies back. The claim was that the carrier was too late because they hadn't followed the statutory timelines under the Right to Recover Act, which is pretty short for getting some of these responses in. Liberty said, no, those don't apply because there was actual damage here. And the court agreed. The court said that these particular statutes here don't address actual damages or common law claims that might have still existed. So basically they said that although everything's got to go through the Right to Recover Act, you can still have claims that are outside that if there's actual damage. So that's kind of a little loophole for some of those claims that we may see as coming up in the future. That's it. I will be around afterwards if anybody has any questions. My email is dblinn@lowball.com if anybody ever has any questions. I'm always happy to answer anything, and I've always told people, if I don't know it, I'll be happy to tell you I don't know it, but I'll also look it up and get back to you, because I like to learn new stuff too. Okay? Thanks a lot.